Were you working or?
Yeah, I had a job. I just had the one today.
Okay. So, I, did you read the document that I had prepared? The
Which one was that? Sorry, you do prepare a few.
I know today morning the document that was sent. Did you read that?
This is for Lulu's matter.
No.
No, I didn't think so.
This is the Gorton one about the originating motion.
I had a quick look at it when I was on the train. We've listed all the issues about the issue about why it should be why he's wrong. I did read that.
No, so this is about the originating motion and him saying that
all
the company, the proceeding against the company was not started properly.
yes.
Okay, so
we talked about it this morning.
I know. I just want to make sure that it's.
No, that's what we talked about this morning.
Okay,
Yeah.
so this is what I'm doing now. Okay, basically I'm trying to complete the report about Gorton that I'm drafting. There's still at least 12 hours or so of work from where I can see it. There may be more. So I'll either send it tomorrow or day after, definitely. But basically, what the report will say is that Gorton and people like him, they create serious problems in 5 ways. First, they pervert the course of justice, and I will set out the specific ways in which he's done that in our proceedings. Secondly, he's corrupting the public record and vilifying us, and then it will set out all the ways in which he's done that in our case, and through the judgments and so on. And then he's corrupting the functioning of other tribunals. So by that, it's he's basically IBAC has started lying and cheating because of him, or done more of that because of him. He specifically influenced Quigley to throw away a case which we had won. Ganay had basically ruled that the only thing that needed to be decided was whether the audio recording was genuine. Otherwise, what the police had done was wrong, and the IBAC had done was wrong. And Quigley then came out and said, no, it will interfere with IBAC's investigation or whatever, a point that they had not even raised. Then he's corrupting the court processes. So I now have proof that he's the one who's been triggering the registry. Because
how's that?
There's a number of ways I can prove it. Firstly, I recorded the registry's calls and the specific excuses that they gave, which are very peculiar. He repeated them in court over, almost a year later. So it could not be a coincidence that happened. Then he. One second, Lulu's calling. 1 second.
Yeah.
Lulu, I'm on a call. Don't.
Hello?
Yeah.
Sorry?
I'm on a call.
Did you say? Okay.
What do you need? Very quickly.
What bread do you want? Also,
Okay.
the monster is not also.
Okay, Lulu,
Yeah.
stop bothering me with bullshit. Just do what you have been told. Bye.
What bread do you want?
Just the pumpkin seed thing is fine. Alright, bye. Yeah, so there's a few things there, but in the transcript as well, he keeps saying that the registry should have been, more strict in dismissing things, which, by the way, cannot be dismissed by the registry because it's a judicial determination, and the judicial determination is wrong. And then there's circumstantial evidence that creates a very high probability that that he's influencing the registry. And the other thing to contextualize it against is that the registry. So if he's not influencing the registry, then there's two things. Either the registry is itself against me, which is not the case, because they weren't always. And secondly, it means that someone else is doing it. So two judges acting rogue, where we don't even have any idea of who the second judge is less likely than Gorton acting rogue.
Yeah, well, registry have just decided they're going to be played.
No, they wouldn't decide that because they have nothing to gain, and also the people that have started acting up are people who were always scared of me. Rodney Radcliffe, I spoke with him on the phone several times. He was complimentary. I mean, in January 2023, he wrote a letter to me saying that, when I complained about the fact that this creates prejudices, he was like, come on, it can't create a prejudice for you. You know everything and blah, blah, blah. I mean, there's a very firm and consequential change in their tact. And at one place they even said to me that the common law judge had instructed them to not speak with me and so on and so forth. They implied it was Dixon, but couldn't have been Dixon. Anyway, and he was the guy who had complained to Dixon as well. There's a number of things, you don't remember each thing, I don't want to go through it in detail, but basically it's not improper to allege that.
No, I don't have an issue with that.
Yeah, so those are the 5 ways in which he's corrupting the process. And we detail the thing. And then I'm going to say some very nasty fucking things, okay? I'm basically going to say that I'm going to use the profiles that the different studies create. And I'm basically going to say that it's important for people like Gorton to continue to corrupt the process because he doesn't have skill, he's very fucking insecure. And the way he survives is by making friendships in an area of work where you cannot really have those. He takes the fucking networking approach and so on and so forth. And what I will say is that everybody has a moral imperative to. I mean, he's basically lynching people. Like, the literal definition of lynching is basically a mob trial. You don't have to kill people for it to be lynching.
Yeah, no, that's fair enough.
So we say that, I mean, I will write the letter, but I will write it on behalf of everybody, and I'll say that, in essence, everybody agrees with me, even though the expressions are mine. But what we say is that we feel we have a moral duty to the people that he's currently judging as well. Like, he's literally in a murder trial at the moment. Lulu tells me. I'll get the details before I write. But, I mean, a judge like that should not be. Now, we're not going to tell those people directly, I will say, because there's arguably the issue of whether or not that will be improper. But we will raise the matter with the Attorney General and the Chief Justice and everybody else who has a process. By the way, I found literature I found the actual text that they teach judges with. So there's an organization that is responsible. It's a global organization. It's an alliance of the judicial oversight bodies from all countries that cooperate with each other, Australia being one of them. And they're together responsible for teaching judges. So every year they conduct these training, seminars or camps or whatever. Yeah. So, and then judges and prosecutors, it's both judges and prosecutors, they're obliged to attend. And that's how they get trained. And I have the material that was presented at those conferences. So it was a combination of Australian people that presented the material, and there was one from a neighboring country, and they set out the objectives of the. I'll send it to you, basically, but they set out the objectives of judicial training and blah blah blah. By the way, no one teaches them about the law. So when they train judges, they don't teach them about the law. They presume that they know about the law. What they teach them about is there's a few areas, but they teach them about how to write reasons, like what they need to focus on when they're writing reasons. They teach them about some things about human psychology and how people behave and perceive things and so on, so they can be respectful to people during trials and blah blah blah. They don't teach them anything about the law. Basically, they teach them about justice and the philosophy and history behind it and blah blah blah. But the main features that they highlight repeatedly, they say there are 3 things you need to have to be a judge. The first thing they say is competence. The second thing they say is independence, and the third thing they say is impartiality. So, and then there's a whole philosophy of good judicial decision making, and there's like 13 attributes that have been identified. So, so this text was actually published by the government of New South Wales. They sort of published the report that I think it was the Judicial Commission, and I'm going to attach that as well. But the point is that there's 2 things. One, no one is teaching them about the law, and the text actually makes it clear that they don't teach them about the law because their training is not focused on like legal qualification, and it's really absurd because nobody actually checks whether the person is legally qualified. Like there's no check that someone has the prerequisites to be a Supreme Court judge.
Yeah, I mean, it used to be pretty much, those who were, you pretty much had to be back in the day, a QC to become.
Gorton was a QC.
Hmm?
Gorton was a QC.
Yeah, no, but I'm saying pretty much you had to be, and back then, but also back then there was not the huge number of QCs that there are now.
Yeah, I mean Norton is a QC.
Yeah.
You couldn't fucking hear her voice in the transcripts,
but also too, honestly, I'm surprised you're saying Gorton's doing a criminal trial because, it used to be that they'd have the criminal, the guys who just did the criminal stuff.
Yeah, I know. It's crazy.
Yeah, I mean, that's really, when you said that the other day, I was really quite surprised too. There used to be,
I mean, it's so fucking perverse, Gorton doing a Supreme Court criminal trial.
Mm.
I'm 100% sure he doesn't know about all the things that go into jury selection and this fucker doesn't understand basic issues about procedural fairness. One party.
No, I totally agree. That's what I thought it was strange. Because, there used to be 2 judges that had the same name, and they were referred to as, Criminal John and Equity John. Or which one you were talking about, Equity John or Criminal John? You knew that one was obviously doing the equity stuff, and the other was doing the criminal stuff.
It's just fucking ridiculous. He doesn't have basic. There's another concept in criminal law. It's called unanimity principle. So basically, what happens is, if someone is accused of murdering someone, yeah. So let's say someone is accused of murdering someone by first stabbing them and then throwing them off a roof.
Mm-hmm.
Okay. What the judge in the trial is supposed to make very clear to the jury is that it's not just that they need to agree on, and I'm taking a very extreme example here, but normally it's not such a nuanced thing. It's the distinction is very clear. So what the judge is required to do to prevent a mistrial is to clarify to the jury that not only do they have to rule that the person killed the person, but they also must agree on how that person died. So it's not that 10 people, 4 people, I don't know how many there are, let's say 10, that 4 people say that he died, when he was stabbed, and then the dead body was thrown off the roof. And then the other 6 say no, he was alive after the stabbing, and then he finished it off by throwing off the roof. If all of them agree that he killed him, but there's a distinction between the two process, then it's a mistrial. Okay?
Yeah, no, I get that.
There's no way Gorton knows about any of that shit, because what he was saying is that everybody knows that they were charging you with this particular offense, even before they had particularized it. Do you understand?
Yes.
Like, those two things are fundamentally incompatible. So,
It's surprising for good night.
and I mean, he was saying to Lulu, he was like, what are you talking about? Like, you should get right to privilege against self-incrimination in this matter, and blah, blah, blah. He was like, I've done loads of, work cover things where people basically get accused of statutory stuff. And, they don't get any criminal law protections. So, I mean, he said that on the transcript. And it's not even a fucking debatable issue, because the High Court has repeatedly, said what the thing is. So I'm going to raise all of those things. And basically now we're arguing fraud against Gorton in a very direct way, because we have clear evidence of fraud. To whatever extent there could have been any doubt left, 2 things make it very clear, okay? And that's what your position is now. Like, he's not a judge and he's a criminal. And the 2 things that make it unequivocally clear, I mean, there's a lot of other things too, but 2 things perfectly clear. 1, he said to McAuliffe that when McAuliffe said that there was evidence in Isabella Ceceri's affidavit of the PDF thing, he said, I've read the affidavit, there's no evidence of it. During the trial, yeah? And there is actually no evidence of it. In fact, Lulu said that there's no evidence of it during the thing. He shut her up and he says later. Then he never got to it. And then in the submissions, McAuliffe said that McAuliffe presented the argument and the screenshots and blah, blah, blah. And what he said is that we have analyzed it through our Adobe software, and this is what it shows. Now, there's no evidence of it anywhere. And even what he's saying is bullshit, because he doesn't understand how technology works.
Right. Yeah.
Then Gorton said that they have given evidence that, and he distorted it further. He said that we were using Adobe, not they used Adobe. So he said they have given evidence that we used Adobe, whereas what this one McAuliffe had said is that he or the LSB has analyzed it through their Adobe software.
Yeah, no, you've raised this, you've mentioned it.
So this is clear fraud, right? This is not something that you can get wrong or be mistaken about. Okay? I mean, it would be an extreme thing.
Clearly wrong.
Not clearly wrong, it's dishonest. It's deliberately dishonest, because I mean, one could say that, maybe he was under so much pressure and maybe I got him to hate him so much that, he psychologically, concocted it. But the difference here is he specifically said in the courtroom that I've read the affidavit, it's not in there. Do you know what?
No, that's pretty damning, isn't it?
I mean, he changed his position, then made it worse. Exaggerated the thing. And shut Lulu up. After he had kicked me out. Okay, that's the first thing. The second thing is that what he did with the People Shop originating motion.
Yeah.
The whole thing was based on the fact that in the tram tracks, where we say prepared by People Shop, blah, blah, blah.
Yeah, no, you said that's a small.
Mine said prepared by Shivesh Vuksal, but if you look at the back of the originating motion, it says, it lists the parties and who they are represented by. It says People Shop, in brackets, represented by Peter Ansel. Okay? So he misrepresented what was on the originating motion. I scolded him. I said that, listen, you can't fucking put 7 names there. I predominantly created the thing. It doesn't mean other people did not contribute to it. And also, here's the other thing. Each lawyer does not prepare the originating motion himself. So, not only can you endorse the thing anyway, if someone else has prepared it on behalf of whoever you have the right to represent, but Section 13 of the Uniform Law basically says that whatever a lawyer can do, his staff can do. Except where the statute prevents you. So the statute prevents you from representing parties in a trial, because literally it's in the Court Act that only a lawyer will represent. So, but otherwise, other than that, whatever a lawyer can do, their associate can do. So anyway, as your agent, I was authorized to draft it. It's no different than me being a law clerk. Sorry?
He accepted that initially too. He accepted that I was allowed to issue it, or I was able to represent.
No, he's not disputing that you were allowed to, but he's saying that I did it. And what he's doing is basically fanning this, allegation that I'm engaging in unqualified legal practice without any basis. And what he's missing in all of this is that I'm the fucking sole beneficial owner of the company anyway. So it's not like I'm using you to represent someone else.
Yeah.
I mean, I would be instructing you anyway. It's like me instructing you to bring these claims, then me drafting those claims as a clerk or your associate, and then you ratifying them. I mean, your job there is not even to make sure that you're doing right by the client, because it's the client's fucking instruction.
Yeah.
All your job is...
That happens all the time, in the bigger firms. There'd be,
Forget about bigger firms. In smaller firms too.
Someone else is always drawing me.
Yeah, in every firm. I mean, even sole practitioners. To say that the sole practitioner should be able to do every aspect of their work is stupid.
No, I agree with all that.
So, okay, the LSB accepted this argument. The LSB accepted...
No, I suppose the only thing is that we get the same... We'll just keep getting the same response from him, won't we? It's just he'll say, well, take me to appeal.
No, you're not getting it. Let me just continue what I'm saying. So, what we're saying is that in this particular case, we can prove that he committed fraud because not only was it perfectly justified, but the point is that the only authority that he cited basically said that this is not an issue if the other side doesn't take an issue. That's what I've quoted the text from the authority in the document that I sent you. And basically what they said is that even if the other side files a practical test suggested by Lord Denning in McFoy versus United Africa Company for distinguishing between those irregularities in proceedings which render this same void or voidable only was whether the irregularity was of such character as might be waived by the other party. So he's saying the difference between irregularity and nullity is whether the thing that is not done exactly in accordance with the rules, it can be cured by the other side not taking an exception to it. And then he says, we see no sound reason to doubt that the irregularities in this writ, in this case the irregularity being an agent who's not a solicitor starting the proceeding, and its issue were of such a character as might have been waived by the defendants by entering an unconditional appearance or otherwise adopting the proceedings as regular. So he says, we see no sound reason to doubt that the irregularities were of such a character as they couldn't be cured by the other side doing that. And then they say this was the conclusion adopted by blah, blah, blah. So that's what they said. And then they also repeated that it is for the defendant to persuade the court in its discretion what the court should do in this matter. So what they're saying is that the purpose of the rules is to help people bring litigation and to cure defects. They're saying it's clear from the way the rules are drafted and the legislation is drafted that it's not meant to exclude the court's jurisdiction, it's meant to cure things, and the other side has to take exception and prove prejudice and say why it should not be done, which is perfectly logical. And in this case, what happened is, this is the exchange between McAuliffe, yeah? McAuliffe says, the primary point in relation to, in essence, the entirety of the originating motion and the plaintiff's further amended summons is the issue in terms of standing. That is, I say that the individual plaintiffs, the persons, cannot claim standing to seek relief on the company's behalf, and then that goes into falls neatly into the next point. That is, the company's participation in the proceeding. Gorton, just the company. The originating motion was filed on 29 September 22, I believe. McAuliffe, yes. Gorton. And that's at a time when Mr. Ansell had a practicing certificate. McAuliffe, yes, I accept that. Gorton, so are you saying that? McAuliffe, yes, Your Honor. The final page of the originating motion. So McAuliffe already knows what he's going to say. He doesn't even let him complete it. So he says, the final page of the originating motion indicates that the fourth plaintiff, People's Shop, he says People's Shop, but it's People's Shop, was represented at the time by Peter Ansell. The originating motion itself, as well as the further amended summons in the tram tracks on the first page, indicate that it was prepared by Mr. Kuksal. Gorton, is it the case that, even on your argument, the originating motion was validly filed in the sense that it was a step taken by a company through a solicitor? McAuliffe, yes. I accept that because at the time Mr. Ansell had a practicing certificate. Yes, however, of course, Mr. Ansell ceased to have a practicing certificate, and then no dispensation was sought under the rules, blah, 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 blah. So, everybody agrees that this is on the 27th of August.
Yeah, well, there's no issue there.
Yeah, so then he ruled that the originating motion was drafted by me, and I'm not a legally qualified person, and so the proceeding was never properly commenced on behalf of the company. That's fraud.
Yeah.
That's fraud because it's fraud because he never even said that I have raised this issue with these people and they have said this, but I still think that they're wrong. Do you know what I'm saying?
Yeah, totally.
At the very least, he should have done that. And this is what...
They're not wrong.
No, then, I mean, it's not for the judge to take the point in the first place. And by the way, this is what he had previously said about the issue, okay? So when I raised and this is why it's an even bigger fraud, okay? It's because he had first raised this issue on the 23rd of August. Then I raised a recusal application and I said that, this is what I said in the recusal application. Your Honor, again, this was not a matter that was before Your Honor. This is about whether or not the originating motion was validly filed on behalf of all the plaintiffs. Now, this was not a matter that was raised by anybody before Your Honor. It's just something that Your Honor took up on your own. And also, there are issues with it which misrepresent the matter. So, yes, the originating motion was drafted by me. But at the end, in the schedule of parties, it is identified that Mr. Ansell is representing the company. In the same originating motion, there's a schedule of parties and it lists who's represented by whom. Mr. Ansell had relevantly endorsed the originating motion on behalf of the company. The company or the specific solicitor does not need to himself draft the originating motion. He can endorse it, especially where there are multiple plaintiffs. There would be nothing improper about one plaintiff drafting a document which then all other parties adopt. That's what happened with every natural person. They endorsed it, so did the company, and that is not to say that it did not have a contribution in terms of drafting the document. It is a reasonable inference that in the prepared by in the small space that is afforded to the prepared by section of the tram tracks, you're not expected to list, 6 or 7 parties. This proceeding has 5 plaintiffs. I did the predominant majority of work. My name is on the thing. There was no reason to cast aspersions on the validity of the originating motion, about which Your Honour had no proper basis to conclude what was concluded. But also, we had not been given an opportunity to address the issue because it was not in contest. In fact, they specifically took away Mr. Ansell's license so he could not later prosecute the matter effectively. Okay, this is what I said. Now, the basis upon which he rejected those arguments was this. He says that I am... Okay, so it's this part of his judgment. He says there's nothing in the allegations that I'm making, because if he pays attention, what I have ultimately said at the end of those comments is that I am prepared to assume, for the purposes of the appeal, that the originating motion and summons were validly on foot. So he says it cuts against my allegation that he's acting opposed to me. I was just thinking out loud there, and it was my duty to think out loud. And then he also says that I have also said that the question as to whether the requirement that people shop act by solicitor can be dispensed with, and it should be determined at the time of the hearing of the matter. He says, if anything, my failure to insist on this point being resolved to date is in Mr. Cooksal's favor. So this is where the fraud lies, right? He refused to recuse himself because he was like, I'm deciding this on your favor. But ultimately he sabotaged me with it, yeah?
Yes, yeah.
So this is a fraud because he tries to, reject the recusal application on one basis, which later on, he will completely undermine. And the other fraud that he's done is, I was continuously asking him to resolve this issue before the hearing, and he refused to do it. And I even complained about it. It's in his judgment. And he says, no, there's no prejudice to it. It can be decided at the trial. And if People Shop wants it to be decided earlier, it can bring its application. Now, he didn't even wait until the fucking trial of the matter. So this is fraud. And basically, what we have to make clear is that I continuously pushed him and created desperation for him, made him helpless, and ultimately he had to do this. I basically, traumatized him into doing this in a very fucking despicable and desperate way, because he knew that okay, there's a third very clear proof of fraud. Okay, I'm gonna quickly say this because I'm gonna say fraud on behalf of everybody, which is why I'm spending a little bit of time in clarifying this. The third way in which I can prove fraud, I'm sure there'll be other ways, but the obvious things that I picked up yesterday. So what happened on the 4th of June was that I said that he is basically preventing us from arguing our case effectively. He's not letting us file the evidence. He's not letting us discover the evidence. And there's obviously every proof of conspiracy here, and blah, blah, blah. And then I said, we want to do the protective cost orders and an actual bias thing. So he says, okay, about your protective clause order application. I said, hold on 1 second. We can't actually do the protective clause application before we get the subpoena decided, because the whole protective clause application is based on the fact that we have a public interest case, and the resolution of this matter is in the public interest, blah, blah, blah. The evidence of their crimes establishes the public importance of this case. Yeah?
Yes.
So we have to subpoena the thing. And then I said, also, the public interest applications have to be heard in open court. That's the whole fucking point of it, yeah? So I was like, those are the things we need, without which we can't hear the public interest application. He was like, well, fuck you. Basically, you're achieving the same thing that I'm trying to avoid through the summary dismissal. He says, basically, what you're doing is having the whole fucking thing done like you would be arguing the whole case, and the summary dismissal stuff gets undermined then, because what we're trying to do is get rid of a lot of the stuff that can be avoided. So I was making the point to him that it cannot be avoided, because it's so fucking intrinsically, involved in everything. This is about justice. And so he abruptly cut off the hearing then. Okay, the matter could not be resolved.
Wow.
Then he gave judgment in which he said that I, or the parties, or the plaintiffs, or the defendants in that case, had basically sought leave to issue summons for a protective clause order, which we never did. Then he said, and then he said that I will waive the requirement for them to file summons. He said that because because it was necessary for what he was going to say next. And because if he by the way, he never fucking waived anything for us ever. He only created more administrative hurdles or procedural hurdles wherever he could. So it was not something that he would do. But anyway, this is why he said that. He said that now he's making an order that we have to file all the evidence about the protective, not the evidence, but the submissions about the protective clause order within 10 days.
Yes.
After 10 days, the court will determine the matter one way or the other. If we don't file the material, then the court will assume that we don't have any submissions to make, and it will automatically dismiss the application.
Yes, I recall that.
No, but we never made the application. In fact, we specifically said that we are not going to make the application until he allows us to. I said that specifically. That we will not make the application until he allows us to get the evidence.
No, I understand what you're saying.
So he said that only so he could dismiss it. And he created this whole fraud that we wanted to issue summons, but he'll waive the requirement, because if he didn't waive the requirement, we would have never issued the summons and the application technically would have never been brought. And he never raised with us, he basically made a self-executing order, which is never made generally in the first instance. Secondly, without giving the other side an opportunity to, he didn't even know whether it was physically possible for us to file it in 10 days or not.
Well, and also you'd already advised him what was the criteria for us to be able to do that was.
So basically, what we have to, what I am going to say is that he knew that, throughout the proceedings, my whole aim was I knew that he was vulnerable, he wanted to hide the evidence. So I used every opportunity to, bring the evidence out. And in the process, I scared the shit out of him, because he knew that so long as these things remained, I could get the evidence out. And by the way, another very clear instance of fraud, fourth thing. Do you remember how Lulu said on the 4th of June, this is pretty big. She said that she wants an order that the lawyer should not be able to draft affidavits or swear affidavits on behalf of VLSB because they don't know anything. And, someone comes in and says that, these people told me this and I only know this, and then they do the affidavits. It's all hearsay. It should be done properly. Remember?
No, I do.
And we have made it very clear that we wanted to cross-examine. And then he puts, what's his name? McAuliffe on notice. He says, I'm putting you on notice that these are the allegations that they're making against your client. That people who don't know anything are basically swearing affidavits to say that this person said this and that. And, I can't obviously order you to have evidence given by a specific person, but these are their concerns. I'm putting you on notice and you know about this. And McAuliffe says, yeah, sure, we've noted all of that. They did the exact same thing at the fucking trial, but now he didn't even let us question the credibility.
Yeah.
So those are 4 instances of clear fucking fraud. That show a deliberate intent and acting upon that intent. Now, the moment I send this letter, what we do then is that you write a covering letter about, also in the letter I will make clear that, we've all had to face extreme fucking prejudice and injustice because he's basically taken away our property rights directly and indirectly. This has stopped us from doing anything. And my challenge was to be prepared to die for this thing without making him look powerful or strong as if he was capable of destroying me, because in my mind he was just a fucking opportunistic infection. And people die of viruses invading their bodies all the time, but it doesn't make the virus any more powerful than what it is. So I will make that point clearly, and the point is that all litigants need to know that all this intimidation and all this stuff can only last for so long if they forensically prepare their case and they're finally able to put the stuff forward. Then you'll do a cover letter where you'll basically talk about all the stuff that we've suffered, and like today it was so fucking embarrassing. What I do, I mean, I could charge as much as the most expensive lawyer in any country for the work that I do. And right now I'm not able to make rent. Do you know what I'm saying? And I mean, it's not something that bothers me or gives me a complex because of my mentality and the way I've conditioned myself, but it is an atrocious set of circumstances. And it's a fact that what I'm doing is not just for myself. In fact, it's only for myself to the extent that I'm interested in getting the principles of this out, and that gives me personal pleasure. But this is fundamentally for the public interest. Because if I were only maximizing my own benefit from the litigation, I wouldn't have gone about it this way. What I'm interested in is getting the truth out. Yeah? And you put that in the letter, and we basically send it to everybody, and we say that it's in everybody's interest to help us get the fucking truth out and see this to the end, because it will give them the tools they need to go after corrupt judges, and it will create public awareness, and that will be the fundraising pitch. Okay?
Okay, just one question though. So, what's Gorton going to do? I mean, what do you think?
Peter, listen, in the letter I will say literally that I will put the transcript as well, and I will warn the Attorney General that if she doesn't, with the letter, I will I will also file a constitutional notice, and the letter will be in support of the constitutional notice, so it will go to every Attorney General. And I will put the Commonwealth Attorney General and the Victorian Attorney General on notice that if they don't fucking intervene in this matter, I will seek declarations that they have. We will all seek declarations, I will say, that they have failed to fulfill their duty to act in good faith to bolster public confidence in the administration of justice. We say that they have a duty, their oath of office, an implication of it is that they will do everything in their power in good faith to bolster public confidence in the administration of justice. And in them, we will accept that they can't remove a judge or pressure him in any improper way, but we say that they have a bare minimum duty to join cause with us and say that this is a proper case for the judge to recuse himself. Not just because we're making allegations
Sure.
of fraud, but because he is not denying those allegations.
Well, I see.
No, but so I will warn them.
Put up or shut up.
No, yeah, I will warn them that they must either charge us with contempt at this stage. And I mean, they cannot fucking charge us with contempt, you know? Like, we would be heroes overnight if they charge us with contempt. Do you know what I'm saying? After providing all this proof of fraud, if they charge us with contempt, then, I mean, Brennan and all the great justices, they've literally said that if a judge is acting in a corrupt way, then far be it from undermining confidence, it will bolster confidence to say that we have a system where even the judge cannot be above the law. And they said that this is not about misrepresentation and showing that a judge has, good character when he doesn't. So basically, what I will make clear from the letter is that now everybody, to the extent that you two were not fully on board in terms of allegations of his fraud, now there's no doubt. Because there cannot be after what he's done. And I mean, the worst aspect of this is that he's deliberately distorted the authorities and done it in such a fucking lazy manner. Like, so he's presented the argument that it's an abusive process for people to seek declarations about misconduct of officials when they can later use it for tortious, for liability in tort law. It's like the authorities say exactly the opposite thing. Exactly the opposite thing. And the authorities he's quoted are against him on that. Like, there's one authority he quoted, and this is the worst fucking thing, okay? Like, he quoted an authority specifically, and he even cited the paragraph number of that authority. And this is the fucking... I'm going to call him all sorts of things for this. So, this is... I think he will not face me in court again. I will fucking love to see him face me in court again. Because one of the other things I will say is that I have to be abusive to him on email because he's tried to shut... Okay. All right. So here's the thing, yeah? He says National Australia Bank versus Nautilus Insurance Pty Ltd at paragraph 19, yeah? Paragraph 19 of that authority. So this is the authority where he says that the declaration about the impropriety of people is not appropriate, blah, blah, blah. And paragraph 19, and then this is what paragraph 19 is. Lulu had sent this to you, by the way, on chat. Just this part and thing. So paragraph 119 here. It was submitted that there is no immediate right, duty, or liability raised for determination. In Commonwealth versus BIS Clean Away Limited, it's a New South Wales case, a claim for declarations that a license had been novated and that the defendant had obligations under it was held to be a matter, as in a matter for declaration. It was submitted that the declarations here would not be as to rights and duties, but only to the meaning of a contract. That, with respect, is artificial and unhelpful as a distinction. The applicant here seeks to resolve one aspect of an overall dispute to clarify the context of its legal rights and the content of the legal obligation of the insurer and reinsurers. That is a matter, it is a contested issue, important to the resolution of overall controversy. It is a declaration of right as to the meaning of part of a contract and rights that flow from such. He cited this paragraph in support of his argument.
Well, it's not the greatest support, I wouldn't have thought.
No. So what the people were saying in this case was that the court should not do this because what happens in a tort law case is that everything about the liability and surrounding factors gets determined, and the side that was seeking a declaration was saying that, well, the law says that no one can stop them from seeking a declaration of right. So the defendant said that no, this is not technically a declaration of right because it's only like looking at one aspect of a thing in the abstract. They said right has to be considered in context of the whole thing, as in what's the total entitlement of this body for the damages. The judge rejected that explanation, and he said that in order for a right to be determined, it should not be, a right that will ultimately get them the money. It has to be a distinct right, and even if it is not the only right in contest or that forms the controversy, so long as it is a right that can be conclusively determined and will settle part of the controversy, the court will do the declaration. That's what he said. And it immediately stood out to me that he raised this thing because the judgment was of Alsop, Chief Justice Alsop of the Federal Court. I know his writings. I've read, he wrote a whole thing about the rule of law and not the law of rules. His whole thing was about making the code accessible to everybody. He was one of the more progressive judges. And to say that he would say something like that, do you know what I'm saying? You can know judges if you read enough about them or their judgments. And what Gorton has done is so fucking perverse. He's trying to corrupt the law. Now when you search these issues, Gorton's judgments come up at the top. And it's such a fucking perverse thing that he's corrupting the law. And this is the thing, okay? He asked McAuliffe repeatedly if he can find one authority that says it's an abuse of process to seek declarations to then use as a thing. They said no. I gave him dozens of authorities. In fact, the Chief Justice of the High Court, Forrest, has written a chapter in the book on declaratory relief in which basically he says exactly what I said. And the rationale for all of that is that we are moving toward a more progressive era in the court's intervention against executive overreach. There's speeches that judges have written in authorities which I've quoted repeatedly. And this is the dishonesty about it, right? He's trying to find one fucking sneaky argument. He's not trying to resolve the law or understand it, because then he would address our authorities too. He's just trying to find, in a very fucking underhanded, sneaky...
It's almost illogical that after determining something that they can determine, obviously.
Why would they not do it?
Why wouldn't they?
Yeah, it's opposed to the fucking oath of office. Do you know what I'm saying? Like, there's this guy, Grant Donaldson. He's now an SC, but he wrote a chapter in that book of declaration before he became an SC, and I'm gonna write to him as well about this case because this is totally what he was saying. So he said that judicial discretion, he said, is perhaps one of the most, he said something which meant offensive. I think he could have said, but he said it's one of the most obscenely abused terms in legal literature, right next to practical necessity or whatever. And he said that basically it is a catchphrase that lazy and incompetent judges use when they don't want to do the work of, evaluating the complicated circumstances and doing the right thing. Says judicial discretion is like the catchphrase that every fucking lazy and incompetent judge uses. And he says it's one of the most obscenely abused terms in the thing. And I've read that to Gorton repeatedly. So that's what Gorton has basically been trying to do. And by the way, do you know what? After that, the VGSO has just filed an application to have my Olney matter and the York matter dismissed on the same principle that I'm basically now seeking determination, which can only help me in tort law cases because the proceedings have been withdrawn, so I've already benefited to the extent that I could have benefited from that intervention like that. And I mean, the absurdity of it is that if that were the case, why would Ghanay, say that let's do it after the trial and not just dismiss it? Do you know what I'm saying? If they were right, then Ghanay would have just dismissed it and said, this should go to the magistrate's court. They decide if there's a problem, we appeal. But what he said is, if they've done the wrong thing, I have a right to have the court affirm that, but I should do it after the case is over. So this is an abuse of process, basically, because they've already lost that application. They made the application first. They said that this should be dealt with at the magistrate's court and then appealed if the decision is wrong.
Yes.
And now, because of Gorton, they're reinitiating that.
Yeah, right.
So basically, I do this letter. I don't think he will come out here to hear a matter again, but I'm not going to make representations about that in certain terms.
Wondering yourself as to what he was doing.
No. I mean, I'm going to give him a piece of my mind. And basically, what I'm saying, what I'm going to start off by saying is that I apologize for bringing his dad's name into the thing in the letter that I wrote, where I said, that he was only appointed because he was the son of a former prime minister. And then I would say, but I mean, there is no fucking doubt that he was appointed for political reasons. So I shouldn't have said it was his father who did it, but and then I'll say that.
His father died, I think, 20 years ago.
Yeah. Anyway, what I would say is that to even suggest that he was appointed after consideration of merit is an affront to the dignity of every lawyer in this country and to the sensibility of every self-represented litigant who accepts or submits to the jurisdiction of the court, because the court is basically incompetent to supervise the lawyers. So I will say some very fucking nasty things, and if he has any fucking shame, he'll start cutting himself. And I will make it clear to everybody that I will copy Maria, and I'll copy the other defendants in the Dallara proceeding in, and I will shame him like only I can. And I'll also clarify that people have applied for restraining orders against me for saying less. But basically, the law is that there's what he's trying to do is hide from his shame in his fucking chambers. There's no dignity in injustice, and he's perpetrating injustice and then hiding from the shame that he should experience for doing that. So that's basically what we say, and I'd be surprised if he ever. I'd be surprised if Niall doesn't take any steps against him, because it's clear evidence of him, perverting the course. This with the High Court judge's comments. Do you know what I'm saying?
Yeah, no. There's got to be a point. At some stage, something's got to happen.
Yeah, this was never supposed to be. Judicial immunity was never supposed to be, a transparently exploitative thing where judges can rape people and say that I'm immune from prosecution. Do you know what I'm saying?
Yeah.
Like, this crosses over, and I will address that as well. The one problem that this whole concept raises is that ultimately there's no accountability, because even the accountability measures, if the government doesn't take them up on its own, then how does the citizen enforce them? By suing them, right? And if they sue them, the judge has to be a party because his interests are affected. So I'm going to raise all of those issues as well, and this is why I'm sure we will get support. And then once we've put this out, we will apologize to everybody we've not responded to and say that this is why we were doing this and we couldn't respond earlier. But we all need to come together now and use this as a threshold case for the argument against judicial immunity. Because, like, I found a case where a magistrate sought judicial review, either at the High Court or at the Court of Appeal, of the decision of the Judicial Commission to basically take away his, to recommend that he should be removed or he should be subjected to disciplinary action. So if he had a right to seek judicial review of the decision, so does the person whose complaint has been dismissed.
Yes.
And if they do that, then they're suing the judge.
Well, yeah.
The judge has to be a party to that proceeding, right? By the rules of the court, because they have an interest. So if
there's no practical benefit for the judge.
Yeah, but okay, so in that case, the law should be that people should be able to seek declarations of wrongdoing against the judge, but he should not be made to pay for it. But that's not what the law is. The law is that's the absurdity of the law. It's not coherent. Ultimately, what it's saying is that a person does not have a right to vindicate their fundamental human rights when their abuser is the judge. Do you know?
No, I understand what you're saying. It's there will be a lot of people who go, they've been verified judges.
There's so many people, Peter. There's so many people.
I know. It's
And the thing is, there are more people that feel that way than have been honestly wronged. Because even the people who have not been honestly wronged, anybody who loses, feels bad about losing. Most people are unreasonable, so when they lose, they think that the judge was wrong. So the support that you get is more than just the people who've been honestly wrong, and that's the democratic process ultimately that everybody should be able to criticize. Anyway, so this is
it's not about justification. That's the point.
no. And in fact, there's been studies done where basically the studies done to clinical standards where they found that judges generally suffer from an overconfidence bias, and it's also been found that what judges do is they tweak their fucking reasons to make their judgments look coherent. You know, they basically ignore the evidence that doesn't fit in with their narrative, and so on and so forth. So, and by the way, the literature that you know, what they teach judges in the training, that covers all of that stuff. Whatever I'm saying is not new. Like, people know about it, it's discussed openly, and what Gorton has been doing is in breach of all, even those requirements, and those requirements in themselves are not sufficient. So we basically address, I'm going to obviously write it on behalf of all of us, but I'm going to address Keo and the Chief Justice now. Keo is the head of the Common Law Division and the Attorney General, and we will basically say that we're concerned about Gorton's, you know, ignorance about the law of evidence, and his, you know, very fucking poor grasp of the Constitution. Well, administrative law in particular, the constitutional law. I mean, this fucker ruled that there was no human right issue involved in the determination of the applications. When it was pointed out to him that there's privilege against self-incrimination that's involved here, and so on and so forth. So, okay, all right. So I'm gonna, you know, try and push this through, and then we basically, I will also send him a copy of the lawyer A affidavit with the redactions and the redacted letter that you had sent. And I think we send it to all the attorneys general in the first instance, and also the shadow attorney generals in all the states and the Commonwealth. And then you do a cover letter, and we send it to the profession, and we basically do the fundraiser with it. And I think, you know, this is now a concrete thing. I'm sure we will be fine, and I'm sure we will get on the news for this as well, because you know, there's clear evidence, and it's a very serious thing. So, and
no, sounds good.
yeah, and also with the federal court, we basically file the constitution notice, and we say that in the bankruptcy matter, the federal court has to first determine whether the trial was done according to the law. That Gorton did. Yeah, and in the letter I will tell him that, you know, it's in the interest of maintaining the dignity of the court system that he put a stay on his orders, because otherwise it's just absurd. And by the way, in that proceeding, which was before the High Court, where the judge said that, you know, they should tell you if they communicated, the person was also seeking prohibition against the enforcement of the orders, court orders that were made against him, on the same basis.
Right.
Which is logical, you know. So we side on that, and we basically say that this is how the process should normally fucking work, you know, like as the High Court says. All right, thanks for that. Where are we with the transcripts, by the way? Have you guys finished the thing?
I've finished off the last two. There's been a number that have just been added. Not to the priority, that's all done. The second ones are all done. There's another category that's been increased.
There was nothing added over the weekend. Like since Friday, nothing was added.
No, well, the priority ones and the second tab have all been done.
Okay, so I will get Lulu to identify overnight which ones need to be done, and then, you know, tomorrow let's start finishing them off. The priority ones were the ones that I had to include in the.
They're all been done. And
Yeah.
the second lot of ones have all been done.
Yeah. So the only benefit of doing the transcripts right now is that we claim costs about that in the injunction proceeding. So before the matter is heard, and I suspect it will be heard this week, because I've also written to the federal court last week and said that it's bringing the administration of justice into disrepute that LSB can open-endedly get this order. I'm sure whenever the judge is appointed, they will rush this matter, and they have to as well. So we just want to make sure that by the a day before the hearing, we can file the transcript so we can claim costs about that. And with the Gorton letter, they will look so fucking terrible, because that's the only thing they have going against us up until now. That they've got these orders against us, and that's why we're trying to do this. And A, that's a stupid argument, because they have to prove it beyond reasonable doubt, because it's a criminal thing that they're bringing. And B, once we take away the Gorton argument from them, they're just plain fucking scoundrels. Do you know what I'm saying?
Hopefully, yes.
No, Peter, we will win. There's no doubt about that, because if he had any power, he wouldn't have had to do it so shamelessly. Do you understand that? Like, if he could stop this from happening, he wouldn't have been disgraced the way he was. Like, he had to openly lie in a way that he would get caught. If he had any influence, he would have stopped that. So he will get exposed, like everybody does. And I mean, with the High Court matter, where the judge was conflicted, that took 4 years. It's just a... Sorry?
Okay, on that note,
Okay.
I'll speak to you later.
Cheers. Bye.
Okay.